till yesterday, Lordship, pertaining to a Lordship, allotment of market in South Salman Market, Jila Panchayat, Lordship.
Panchayat,
Pertaining to a market, Lordship, allotment of
Panchayat or municipal board?
under the Panchayat and Rural Development, Lordship, the Jila Parishad has issued the tender notice.
Huh.
Lordship, there are some clauses, arbitrary clauses, which makes us ineligible to apply.
Can it be tomorrow?
Yes, sir, tomorrow. Obliged.
Please, Lordship, I beg to mention for listing of a contempt matter, Lordship. Matter relates to non-payment of contractual bill, Lordship.
Okay, next.
There are 7 matters, Lordship, but same petitioner, Lordship. It's a series, Lordship.
Please,
Much obliged.
May I please, I beg to mention for listing for order, my lord, in this case, your honorable court passed an order to take step against respondent number 9, but
Yes.
by mistake, the order, it has here, the respondent number was wrongly printed.
I will deter it.
Obliged, my lord. May I please, Doctor, will like to mention item 9 here.
Item 9, yes.
Doctor, may I adjourn for
For the day.
And for the respondent, ma'am.
Okay. What is the matter?
Doctor, matter pertaining to BIS, your honor. BIS, Bureau of Indian Standards.
When do you want?
Doctor, any date after
After long vacation?
for your October?
Long vacation?
Yes.
2nd of November? Oh, no. List con. Helicon code. Helicon, my phone is anybody. Helicon color phone anybody. But you have one. Oh, but you have a police. 7th of November or 9th?
Yes, sir.
After
Yes, sir.
9th? Okay. Mr. P. Borua,
PK Boyd.
P.K. Bora. On the prayer of Mr. P.K. Bora, Learned Counsel for the petitioner, placed the case on 9th of November. Mr.
B. Hazarika,
B. Hazarika, Learned Counsel for the respondent number
226.
226. Yes. Anybody, Union of India?
Doctor, I think I've informed them.
Okay. 226 has is in attendance and has agreed to the safety. It is submitted that Learned Central Government Council has been duly informed before making the prayer. You informed
Yes, yes. Very interim.
the interim order. Past earlier shall continue listening.
Yes, yes.
Hello.
I beg to mention for listing. I beg to mention for listing for next week.
Bit louder.
May it please your lordship, I beg to mention for listing for next week.
What is the subject?
Matters relates to non-payment of contracted bill.
Conflicts will make quick video.
Top of the list, item number 1.
May I please, Lordship? Lordship, kindly matter will pass over for the time being.
No passover. Yes, you are good.
I have filed an affidavit. I have filed an additional affidavit, my lord.
When at the time of hearing,
No, my lord, that is necessary because your lordship raised the question whether the workman is a protected workman or not. And my submission is that he is a protected workman. And
submission is okay. What evidence?
yes, evidence is there, and that is why I have filed this affidavit.
No,
Because-
hand over a copy. Have you furnished a copy to Mr.
Yes, I
Somoria?
have already.
On it.
The clerk has submitted.
Okay, on it. Anyway, Lordship, if the part of report, there is no research to oppose, I will take it. But question is that, my lord, the evidence will reflect. LCR is there, my lord.
Let us see what kind of additional
Out of
evidence
reading,
after 10 years.
No, my lord, he is a protected workman. He submitted application as per 33 AB, my lord. And that was received by the management and they accepted it, my lord, as a protected workman. And thereafter various negotiation is going on, my lord. He being capacity of a General Secretary.
Copy as well,
With a receipt person. Yeah. Yeah. And I have annex to annexes, my lord. That is annexer 12, page 56. He submitted the application on 17/4/2005. And they have management received the application.
Received the application, okay.
Yes.
Then what happened thereafter?
Therefore, they accepted, my lord, because
No.
various negotiation going on, he in the capacity of a general secretary, and they never, as per.
This
law,
is received. Annexer 2, your Annexer 12
Yes.
is received.
Yes.
Now, what does the rule say?
I'll take the budget.
What does the rule say?
Yes, I'll take your lordship to something.
How rule can you say to the asil? That was this part. This part was mentioned in the writ petition.
That was mentioned, my lord.
That was mentioned in the writ petition order, earlier writ petition.
No, my lord. That is, my lord. Yes, that was mentioned. That was mentioned, but that document was not before, before the court. That is,
Now we have seen it.
yes.
So does it
I will take your lordship to 33(3).
33
33.
industrial disputes act?
Yes. It says, my lord, notwithstanding anything contained in subsection 2. Has your lordship got it?
Yes.
Notwithstanding anything contained in subsection 2, no employer shall, during the pendency of any such proceeding in respect of an industrial dispute, take any action against any protected workman concerned in such dispute. A, by altering to the prejudice of such protected workman the condition of service applicable to him immediately before the commencement of such proceeding, or by discharging or punishing, whether by dismissal or otherwise, such protected workman, save with the express permission in writing of the authority before which the proceeding is pending. Explanation. For the purpose of this section, a protected workman in relation to an establishment means a workman who, being a member of the executive or other office bearer of a registered trade union connected with the establishment, is recognized as such according to rules made in this behalf. 4. In every establishment, the number of workmen to be recognized as protected workmen for the purpose of section 3 shall be 1% of the total number of workmen employed therein, subject to a minimum number of 5 protected workmen and a maximum number of 100 protected workmen. And for the aforesaid purpose, the appropriate government may make rules providing for distribution of such protected workmen among various trade unions, if any, connected with the establishment, and the manner in which the workmen may be chosen and recognized as protected work. And there is, my lord, thereafter, as per direction, my lord, Assam Industrial Dispute Rule 1958. That is before your lordship, my lord. I'll take your lordship to Rule 64. Protected workmen. Every registered trade union connected with an industrial establishment to which the act applies shall communicate to the employer before the 30th September every year the names and addresses of such of the officers of the union who are employed in that establishment and who is, in the opinion of the union, should be recognized as protected workmen. Any change in the incumbency of any such officer shall be communicated to the employer by the union within 15 days of such change. 2. The employer shall, subject to section 33, subsection 4, recognize as workmen to be protected workmen for the purposes of section 3 of the said section, and communicate to the union in writing within 15 days of the receipt of the names and addresses under Rule 1. The list of workmen recognized as a protected workman. Where the total number of names received by the employer under Sub-Rule 1 exceeds the maximum number of protected workmen admissible for establishment under section 33, subsection 4. The employer shall recognize a protected workman only such maximum number of workmen. Provided that where there is more than one registered trade union in the establishment, the maximum number shall be so distributed by the employer among the unions that the members of recognized protected workmen in individual union be roughly the sum portion to one another as the membership figures of the union. The employer shall, in the case, intimate in writing to the president or the secretary of the union the number of protected workmen allotted to it, provided further that where the number of protected workmen allotted to a union under this sub-rule falls short of number of officers of union getting protection, the union shall be entitled to select the officers to be recognized as protected workmen. The selection shall be made by the union and communicated to the employer within 5 days of receipt of the employer's letter. And clause 4 is important matter sub-clause. Where a dispute arises between an employer and any registered trade union in any matter connected with the recognition of protected workmen under the rule, the dispute shall be referred to the Labour Commissioner Assam, whose decision therein shall be filed. My lord, here, my lord, the management accepted the workmen as protected workmen,
No. Accepted the letter.
accepted the letter. Thereafter, my lord, no formal order is there. But my lord,
Sub-rule 2 of Rule 64 requires communication to the union in writing within 15 days.
no, that my lord, that letter is there, my lord. And what is
So if it is not recognized by the management,
no, my lord.
then what would be the option?
If
Labor Commissioner would declare. That is the law.
And my lord, if they are not satisfied, my lord, that they say that he is not a recognized workman, they did not accept the letter, then they will come under section 4, my lord, but no.
4.
action has been
So
taken.
there has to be determination by the Labor Commissioner.
The labor
Unless
no,
determination by Labor
the
Commissioner,
labor commissioner
suppose management refuses. They have not given any communication in writing.
no, labor commissioner report is before your lordship in annexer, my lord.
No, that is union.
Annexer 5. No,
I have seen.
no, it is by assistant labor commissioner.
Yes, which file?
And main lead petition, my lord.
Yes.
Annexer 5. Letter dated 5th January 2005. Because later.
That is his claim.
No, my lord. A labor commissioner accepted.
No, where is the dispute decided? Where is the dispute decided? He on his own cannot declare. There has to be dispute. Sub-rule 4 regarding protected workmen also.
In every establishment, my lord, sub-rule 4. The number of workmen to be recognized as protected workmen for the purpose of section 3 shall be 1%. My lord,
No, sub-rule 4.
sub-rule 4 of my lord.
When a dispute arises. Sub-rule 4 of Rule 64.
Yes. When a dispute arises between an employer and any registered trade union in any matter connected with the recognition of protected workmen under this rule, the dispute shall be referred.
Where is the reference?
My lord, here, my lord, my point is that when management accepted it as a protected workman, my lord. There is,
Okay.
it is their duty, my lord. They did not raise this.
Okay,
And in fact, my lord, assistant labor commissioner by annexer 5 of my.
I have seen it. Where he decided, Annexer 5. Where is the reference to decide that? Annexer 5,
Your lordship permits me, I will take your lordship to annexer 5, my lord.
yes, page 20.
It has been alleged that Shri Bacha Babu Singh, General Secretary, Steelworks Workers Union, who has been transferred to Kannur on his protest against your order. You have withdrawn the token card and stopped his work illegally. This is letter to the manager, my lord. As you are aware that Shri Singh is General Secretary of the Steelworks Workers Union and as such is a protected worker.
Right, I am
Right.
asking you the question. That sub-rule 4 requires a reference when a dispute arises. where he has decided, he has assumed a jurisdiction without first deciding, he has declared him as a protected workman without first deciding any kind of reference. When the management did not recognize him in writing that he is a protected workman.
No, that is was the system going on, madam. That is what the
The
system.
rule, I am only referring to rule. I am not here for empathy or sympathy. I am only on the precisely on the rules and regulations in force.
And my submission is that
Yes.
they have received the letter, my lord, and
Okay.
thereafter, my lord, he was treated as a protected worker in
Okay.
various proceedings, my lord. He is represented as Sangha, my lord.
There is no dispute about that. That
In various.
BB
proceedings.
Singh is representing the trade union
Yes.
before the assistant labor commissioner for the bonus purpose. There is no dispute to the fact.
Not only bonus purpose, on all in all disputes. my
No.
lord. No, that-
Conciliation proceeding started. Conciliation proceeding started prior to the order of transfer.
Yes.
Right?
Yes.
Prior to the order of transfer.
and during proceeding of the conciliation,
During conciliation proceeding,
he was done.
he was transferred. Right? The question is whether he is a protected workman, whether in such situation he can be transferred, whether he comes under 33.1, 33.2, 33.3, 33.4, 33.5. So everything is on 33, right? Not beyond 33,
But
and subject to rules framed for that purpose. Nothing beyond 33. So we have to decide that. So according to you, he is a protected workman. If it is a protected workman, what is his condition of service?
my lord, he is a temporary worker.
1 minute.
Temporary.
What are the evidence laid before the tribunal? Because we cannot go beyond the reference. And tribunal also cannot go beyond the reference.
That I will.
Reference is first two issues. One, whether the management of Steel Works Private Limited, Makum Road, Tinsukia, is justified in stoppage of work of Bachababu with effect from 5/1/2005. Now, second is hinges on the answer to the first. If not, he is entitled to reinstatement with put back wages with effect from 5/1 or any other relief. So if the answer to the first question is in the affirmative, then second question is need not to be decided. So if the first is not in the affirmative, then we will go to the second. So only distinct 5/1. Now what is his appointment? You want to say he is daily rated?
No, he was subsequently, that is my case, my lord. He was daily rated, but he was subsequently confirmed, my lord.
Confirm.
The permanent worker, my lord.
Do you have the standing order? Because management letter, I've been referring to a standing order.
And in his evidence, it clearly stated that he was initially as a temporary helper and subsequently he was confirmed, my lord.
Now, 1/11/2006, 1986. Your appointment order.
Yes,
So you are confirmed.
Yes.
Right? With effect from 2/11/1986.
1185.
Now, do you have the appointment order with you?
One mail letter, not, but in evidence, it is clear, my lord.
Ah,
that I-
it is there.
It is.
So, clause 3, transfer
Was free of my lord.
clause. Your place of posting will at present be at Tinsukia. You are liable to be transferred to another branch or shift or post, etc., or place or to sister concern, whether in existence or which may come into existence hereinafter. This is the appointment letter which has been duly accepted. Declaration, I have read and understood the above terms and conditions and agree to abide by the same. His signature is appearing. And it appears from the initial order. Your submission was that the concerned workman is a daily rated worker, which is not correct.
He is subsequently confirmed. That is
1986. 1986, MS Bhattacharyji. Appointment order is of 1986.
Yes.
And repetition was moved in 2013.
2000.
Now, come to page section 33.
Award is of 2012, my lord. That is by 2013. Award is of
Right.
2010.
Now come to 33 again.
33.
Can you claim any protection under any other subsection? Because so far as section 33(1), right? Kindly see subsection 1. During the pendency of any conciliation proceeding. It is true, before a conciliation officer. It is true. Here, there is a conciliation proceeding. In respect of an industrial dispute, yes, it is true. Bonus. No employer shall, in regard to, now quote unquote, any matter connected with the dispute. So it will be only connected to dispute. Alter to the prejudice of the workmen concerned in such dispute, the conditions of service applicable to them immediately before the commencement of such proceeding, save with the express permission in writing of the authority before which the proceeding is pending. So, any matter connected to the dispute means it is, if the bonus is altered, yes, they cannot. Now come to 2. During the pendency of any such proceeding in respect of an industrial dispute, the employer may, in accordance with standing orders applicable to a workman concerned in such dispute, or where there are no standing orders in accordance with the terms of the contract. Now here is an appointment order where condition is that you are liable to be transferred to any place. There is there. And secondly, standing order they are referring to in every letter I have seen. I have seen every letter. You have annexed the repetition. That not joining will be.
But he is covered by.
Not joining, right. So only saving grace could be subsection 3.
I am covered by subsection 3.
Okay. Anything more?
My lord, again, I will take your lordship to subsection 3, my lord. Notwithstanding anything contained in subsection 2, no employer shall, during the pendency of such proceeding in respect of any industrial dispute, take any action against any protected workman. My submission is that by virtue of the letter, he is a protected workman, my lord, because
Okay, assume.
they accepted it, my lord.
Okay, let us assume for a moment protected workman.
Concerned in such dispute by altering to the prejudice of such protected workman the condition of service applicable to him immediately before the commencement of such proceeding. or
So transfer of service
Yes.
is part of your condition of service in the appointment order. And transfer is not only limited to one branch to another, one place to another.
yes,
So what kind of condition of service has been altered?
the next, madam, B. By discharging or punishing, whether by dismissal or otherwise.
No,
The order
here is a
madam,
question. The dispute is starting from the transfer order leading to stoppage of work. We are not deciding anything about dismissal. We cannot travel beyond neither the tribunal or labor court. This is a tribunal, I think,
tribunal.
tribunal. Now let us see. Now
Impy order.
let us see.
Your lordship may have a look at B,
1
madam,
minute.
clause B.
I have seen enough. Oh. Where are the schedule? Schedule.
That's
Okay. Come to third schedule also.
matter within the jurisdiction of industrial tribunal.
We are industrial tribunal?
Industrial.
Matters within the jurisdiction of industrial tribunal. Sorry. Fourth schedule. Fourth schedule.
Condition of service was changed on which notice is to be given.
Yes, read one by one.
Wages, including the period and mode of payment. Contribution paid or payable by the employer to any provident fund or pension fund or for benefit of the workmen under any law for the time being in force. Compensatory and other allowances. Hours of work and rest interval. Leave with wages and holidays. Dating alteration or discontinuation of shift working otherwise than in accordance with standing order. Starting alteration or discontinuation of shift. Classification by grade. Withdrawal or any customary concession and privilege or change in uses. Introduction of new rules of discipline or alteration of existing rules, except in so far as they are provided in standing orders. Rationalization, standardization, and improvement of plant or technique which is likely to lead to the replacement of workers. Any increase or reduction in the number of persons employed to be employed in any occupation or process of department on shift.
Fourth schedule is relatable to section 9A. Let us see 9A.
9A. Nine A, notice of change. Notice of change. No employer who proposes to effect any change in the condition of service applicable to any workman in respect of any matter specified in fourth schedule shall effect such change without giving to the workman likely to be affected by such change a notice in the prescribed manner of the nature of change proposed to be effected, or within 21 days of giving such notice. provided that no notice shall be required for affecting any sin. Where the sin is affected in pursuance of any settlement or award, or where the workman likely to be affected by the sins are persons to whom the fundamental supplementary rule, civil service classification control rules, civil service temporary rules, revised leave rules, civil service regulation, civilian and defense service rules for Indian Railway, this is not applicable. Other
So neither in section 9A nor in fourth schedule, transfer is included. And transfer is included in your letter of appointment. Now, it is not an alternation of condition of service,
no, my lord.
right?
And
Now, if you also go by 33, subsection 3, come to 33 again. Notwithstanding anything contained in subsection 2, no employer shall, during the pendency of any such proceedings in respect of an industrial dispute, take any action against any protected workman concerned in such dispute by altering to the prejudice of such protected workman the conditions of service applicable to him immediately before the commencement of such proceeding. So your appointment letter says you are liable to be transferred from one place to another. Now that transfer order has not altered your conditions of service. Neither a notice is required under section 9A for a matter to be connected with fourth schedule.
my lord, he is a protected worker and protected.
That division bench has left it open.
No, my lord, I am not, my lord, now, my lord, I am arguing on the law, on the basis of this legal provision, my lord. My lord, he is a protected workman, and that document that I have annexed in my affidavit, that shows that he is a protected workman. Management received the letter, and thereafter various conciliation proceeding was going on. He has the capacity of protected workman. And very purpose of declaring protected workman is that, my lord, union, leader of the union, they espouse the causes of the workmen. So the purpose behind is that, my lord, management to, they can, so that they cannot take.
Purpose is to maintain industrial peace and harmony.
So that they cannot take any vindictive action against a particular leader, my lord. That is why the concept of, and he has been transferred to far away state of Tamil Nadu, my lord, Honnur. That is a vindictive action, my lord. That is why we are before your lordship. Because it is a
কাগজ
vindictive-
এখন দিও। Okay. হব।
But logic behind, my lord, declaring protected workman is there. So that the management cannot take any vindictive action for espousing the causes of the workman. That is the idea behind it. And such a workman, he has been transferred to such a faraway place, Tamil Nadu, my lord. It is a vindictive action, my lord. That is why we are before your lordship. And now he has already retired, my lord, attaining 58 years of age. And management has never, my lord, disputed as per Assam rules, my lord. It says Assam rules, rule 4.
Management disputed, that is why the writ appeal is.
No, my lord.
MS Prasad, writ appeal was for what? They was not agreed by the dismissal of the writ petition. What they had agreed was aggrieved was precisely on that point.
And there,
They argued on only regarding the issue of protected workmen. And the division bench has said everything is left open for consideration for the tribunal.
in spite of labor commissioner's order, my lord. that he is
Who
a
has
protected-
he's decided without referring, without sub rule 4 of 64?
No, my lord.
He cannot declare, he has assumed a jurisdiction without deciding any reference.
No, my lord,
That is not correct.
because conciliation proceedings are by the labor commissioner, my lord. And I will take your lordship again to rule 4 of Assam rules. my
I have read it 5 times till now. I do not intend to read more. Yes, Mr. Somori, I have heard you.
Well, straightway, Lordship, only one thing is important. I have two issues for Lordship consideration. Number one, whether he is a protected worker. And number two, whether in the present form rate petition is maintainable or not. These 2 points I would like to address. Now, Lordship, straight where I am coming to 33, explanation part. Only one line. 33 explanation, 33 explanation part. For the purpose of this subsection, a protected worker in relation to an establishment means a workman who has been a member of the executive or other office bearer or a registered trade union connected with the establishment is recognized as such in accordance with rule made in this behalf. Therefore, rule is necessary. Therefore, in conjunction with 64 Lordship already pointed out, 4 is applicable. There is no disputed that 33 laid together with the 64 4. Now, Lordship, what evidence that has been laid at the time stage of trial? Page 48.
LCR.
No, my lord, read petition, page 41. Impugn judgment. This part I think has not been pointed out.
PS 49.
41, 41.
41. Yes.
Now, Lordship, the line starts from here. Whether he's a protected worker or not. Second line. Now, what are the narration that has been taken into consideration? Then that is necessary. Whether he's a protected worker or not. It is suggested.
Which line?
My lord, second line.
Okay.
It is suggested by MW1 Baldev Singh as per company law and company bylaws, he can transfer the workman during the period of taking evidence. He revealed by the submitting the provision of section 64 Assam Industrial Law on protected worker to explain the court on their authority. It is submitted that for the employee that management has to declare the protected work in every year, and the union shall communicate to the employee before the 31st September in each year to whom management shall consider who will be the protected worker. And it is the duty of the union every year to do that filling the list of that. There is no list of the worker recognized protected worker for the declaration. So, however, it is submitted in this case. They did not declare the workman in question as the protected worker. However, it is submitted that without declaration of protected worker, he or she will not be protected worker. And it is not required to follow any rule laid down by the Industrial Tribunal Act. And there is no reason of taking permission of Labor Department for transfer and even for termination such employee. At the same time, no letter was proved from the union to show that they are protected workmen. As a result of that, there is no any reason to hold that the Bachcha Singh is a protected worker without declaration of the management. But this is the evidence that has been taken into consideration based on the evidences. Therefore, my lord, I think there is no infirmity committed by the learned tribunal below while dealing with the particular issue. Now, Lordship, question is that decision or decision-making process. If decision is, my lord, maybe my lord, substituted by Lordship by reassessing the whole issue. But if process is, my lord, in accordance with law, my lord, to arrive at that conclusion, my lord, that may not call any interference. Now, Lordship, simple support of my lord two contention, I would like to refer some title.
We are in certiorari.
My lord, straightway I am coming to one of the judgments, which is, my lord, I have read, gone through P.H. Kalyani's Air France Calcutta judgment 1963. It has been referred numbers of time afterward also. Page 3, paragraph 5. Page 3, paragraph 5. Meritman. Learned counsel for the appellant has further raised some points which were raised on behalf of the appellant before the labor court. In this first place, he contended that the appellant was the protected worker and the labor court was not right when it is held that the appellant was not a protected worker. We are of the opinion that the question whether a particular workman is a protected worker or not is a question of fact, and the finding of the labor court on such a question will generally be accepted by the court as a conclusive. Besides, the labor court has pointed out that the mere fact that a letter was written to the manager of the respondent company by the vice president of the union and the manager has been requested to recognize him along with others mentioned in the letter as protected would not be enough. The company had replied to that letter pointing out certain legal facts therein, and there was no evidence to show that what happened thereafter. The Labour Court has held that according to the rules framed by the government or West Bengal as the recognition of protected worker, there must be some positive action on the part of the employer. In regard to the recognition of the employee as a protected worker before the court, claimed to be a protected workman for the purpose of Section 33. Nothing has been shown to us against the view. In the absence of therefore of any evidence as to the recognition, the Labour Court rightly held that the appellant was not a protected worker and their previous permission under Section 33 of the Act would not be necessary before this dismissal. This is the observation that has been constituted by the Supreme Court in this 1963 case. Now I am coming to the second judgment, Air India Corporation Bombay versus BS Bello, and relevant part is paragraph 8 and 9 contained in page 10.
Page 10, Air India, okay, right.
Paragraph 8, my lord, here, my lord, the discussions is about 33. That section has been incorporated for the purpose of reference. Now, Lordship, already have Lordship deeply discussed this whole thing. I will not reopen that facts again. Only I am coming to the explanation part, which my lord contained in my lord paragraph 9, page 12. Paragraph 9, page 12. The basic object of these two sections, broadly speaking, appears to be the protect workmen concerned in the dispute which form the subject matter of pending conciliation proceeding or proceeding by way of reference under Section 10 of the Act against the victimizations by the employer on account of ranking of continuing such pending dispute, and to ensure that those pending proceedings are brought to the expeditious termination in a peaceful atmosphere, undisturbed by any subsequent cause tending of further exacerbate the already strained relation between me, employer, and the workmen. To achieve this objective, a ban subject to certain condition has been imposed by Section 33 on the contrary right to the employee, ordinary right of the employer to alter the terms of the employee service to their prejudice or terminate their service under the general law governing contract of employment, and Section 33A provide for relief against the contamination of Section 33 by way of adjudication of the complaint by aggrieved workmen considering them to be dispute referred to pending in accordance with the provision of the Act. This ban, however, is designed to restrict interference by the general rules and rights and liability of the parties under the ordinary law within the limits truly necessary for accomplish the above object. The employer in accordingly left free to deal with the employees when the action concerned is not punitive or malified or does not amount of victimization of unfair labor practice. But transfer is a part of my service, which as Lordship has already pointed out 2006. Therefore, there is no need punitive, malified, or any victimization part. It is a normal transfer course, my lord, which has been put on the challenge. But in the light of Section 9, my lord, if we see that the discussion which has been made in regard to Section 33 clearly says that this element must exist. Now, Lordship, I am coming to another citation of our Honorable Guwahati High Court. My lord, start from page 17. Oil and Natural Gas Corporation versus Union of India, and relevant part in paragraph 11.
Not required issue in the.
My lord, my lord, paragraph 11, my lord, if Lordship not required, my lord, I will not refer. Now I am coming to the second limb of my submission about maintainability of the writ petition, my lord. Whether in the present forum, 226 is maintainable or either my lord, 227 is maintainable, my lord.
Since time long, writ petitions are filed.
Lordship is going to decide, my lord.
That you need not have to, that you should have taken it when writ petition was moved.
My lord,
This plea, have you taken in the in your affidavit of opposition?
my lord, affidavit.
A plea which not pleaded, don't take
Absolutely.
at the
Quite
time
right,
of
my lord.
hearing.
The Honorable Supreme Court says, my lord, in regard to-
Unnecessary submission is not
my lord, these are the
required.
my lord, only
If it is not,
my lord, I leave it to Lordship.
writ petition was moved in 2013 or 2012,
My lord, academic
that
report, my lord, since Lordship is going
plea
to-
was not taken, and there were two earlier rounds, right? Even you came in a writ petition,
Quite right, my lord,
right?
quite right. My lord,
And you preferred a writ appeal.
it's only a law point, my lord. which-
No law point which you have
Quite right.
preferred a writ appeal earlier. Prior to that, you preferred a writ petition earlier.
Lordship,
You should have come under 237
I will
then.
not dispute anything, Lordship.
Then
Lordship,
don't make such submission,
I will not.
which cuts you also.
This is my submission.
Anything to add? PH Kalyani, law is settled, and I have found out recent judgment, 2021, 12 SCC 38.
30, my lord.
3 judges bench,
My 30.
2021, 12 SCC 30. 3 judges bench.
The Kalyani judgment, my lord, which I have found, my lord, in such a situation about 30.
Yes,
Mostly referred, my lord.
that is about subsection 1 and subsection 2. Rendered by decision, judgment delivered by Honorable Supreme Court of Chief Justice of India.
My party.
Dr. D.Y. Chandrasur, that was in reference to 33-1, 33-2,
Party's name, my lord.
and Doraira's Spintex versus R. Chatti Babu and others.
Well.
So, what is meant by subsection 1 and subsection 2? And subsection 3 is protected workmen.
I am under.
It's a well-designed law, my lord, that the protection is being mostly
The
given to
condition is that I tried to find out whether what is your condition of service. I first tried to find out. Then your letter of appointment permits transfer from one place to another of the same company or any office which is to be opened later on. Right? That one part. Section 9A and 4th schedule does not include transfer. Now, it is a condition of service, transfer from one place to another. Now, during the conciliation proceeding, if you read minutely again, even if you are protected workman,
then also apply. my lord.
there is no alteration of condition of service.
Prior to.
If you read again, it is alteration of condition of service.
Quite.
By discharging or punishing, whether by dismissal or other.
Punishing, no, simple,
I may.
Demolition.
include in other
even
ways.
other also. What condition of service has been changed? Transfer from one place to another is in your letter of appointment.
It is there.
I was looking into it.
My lord,
Whether you have been, any change has been made somehow.
more issue.
The limited point is.
That I could not find.
Now, lordship, second.
So you're not joining and law is otherwise. First you join. If it is, there is no alteration of condition of service, or if there is no statutory violation, then you join, then you hesitate.
Quite right.
That is the law otherwise. For transfer, you cannot say, I have to be posted here, I have to be posted there. One cannot.
But that.
This is a condition of service. That is why I tried to find out whether you are not transferable or transferable within the state. No, that is not the situation here.
My lord,
You are transferable.
second point is very important, my lord, that it must arise from the same transaction. Suppose.
That is 33-1.
Exactly, my lord. Suppose, my lord, my lord, my lord, that if you alter anything about bonus, my lord, then, my lord.
Right. That was conciliation.
Yes, my lord.
Proceeding was in respect of bonus.
My lord, service, so many things are required to.
I have to dictate also. So many issues are involved.
My lord.
Why in the writ petition cost title an application under section 148A of the CPC? Huh?
48.
In the cost title, writ petition first page.
In my.
Might be.
Oh, caveat. Okay, it is caveat.
Caveat, man.
Caveat, my lord.
Oh, caveat. So you are in caveat, right? You were in on caveat. So what did you do on the first date? You did not raise question of maintainability of the writ petition.
My
So,
learning
do not
patient,
take
man.
after 10 years.
Well,
Leacock number যাব। The present writ petition under Article 226 of the Constitution of India has been instituted by the petitioner to challenge an award, a capital political, dated 2010-2012, rendered by the learned Industrial Tribunal, Dibrugarh, in reference case number 01/2012 within bracket old case number 04/2008 bracket close. Please take note of the facts if I dictate wrongly.
Yes, yes.
Full stop. By the award dated 2010-2012, the learned Industrial Tribunal, Dibrugarh, decided the reference forwarded to it for adjudication by the Labor and Employment Department, Government of Assam, under Section 10 of the Industrial Disputes Act 1947, and the reference consisting of two issues has been decided by the learned Industrial Tribunal against the writ petitioner dash workman. Full stop. Para. It was by a notification. It will be I'll share it, please 20. bearing number GLR dot 216 stroke 2008 stroke 11 dated 11/11/2008, comma, the Government of Assam in the Labor and Employment Department referred the dispute to the Land Presiding Officer, Industrial Tribunal, Dibrugarh. And the notification read as under page 20. A2A. The case pleaded by the workmen the street petitioner is in the present writ petition is to the effect, is entirely to the effect that the petitioner in his capacity as a general secretary what is the name of the management? Sorry.
General Secretary.
Huh?
General Secretary name is Bacha Babu Singh. General Secretary Steelwork Workers Union.
General Secretary of
Steelwork Workers Union.
Steelwork. Steelwork.
Steelwork.
What?
Work.
Steels what?
Steel.
STEELSWORTH. Steel. Workers Union. Raise the demand for payment of bonus for the accounting year colon 2003-2004 as the management of Messrs. Steel Sword Private Limited refused to fulfill the demand of the Workmen Union, the dispute was referred to the Assistant Labor Commissioner, Tinsukia for conciliation. The conciliation officer vide a notice of conciliation dated 19/10/2004 called upon the workmen side and the management side to hold conciliation on 26/10/2004. Several rounds of conciliation were held and the dispute could not be settled, comma, Assistant Labor Commissioner Tinsukia scheduled the conciliation proceedings for further discussion on 15/12/2004. Full stop. Subpara. While the conciliation proceedings in the matter of bonus for the accounting year 2003-2004 was continuing and pending before the conciliation officer, the management issued a transfer order dated 27/11/2004, whereby the petitioner was is part of the petition.
Yes. Exactly.
Whereby the petitioner was transferred to the workshop of Messrs. Steelworks so-and-so at Kunur, Coonor, Tamil Nadu, Kunur, in the state of Tamil Nadu. Full stop. By the transfer order dated 27/11/2004, the petitioner was directed to report to the manager of the branch, Kunur branch of writer report for joining at its Kunur branch, WEF 15/12/2004. Was that the petitioner was also instructed to vacate the quarter and hand over the keys to the manager within bracket personnel and within personnel, Roman and administration. Subpara. The petitioner has contended that when he, as the General Secretary of Messrs. Union, was espousing the causes of the workmen and was taking part in the conciliation proceedings, he invited the wrath of the management and the transfer order is an act of victimization and unfair labor practice resorted to by the management side. Full stop. Why you are saying that daily rated worker
Our initial appointment was daily rated, but subsequently is confirmed.
Why then you are pleading it in the repetition? Your appointment letter does not say so. It is contended that the action of the management in transferring a workman of his status to a far off place by directing to report for a place like Kunur, Tamil Nadu, is clearly bad malafide and reflects a vindictive attitude on the part of the management side towards the petitioner. First off, when the petitioner may submitted a reply on 6/12/2004 before the management seeking review of the transfer order, stating that he being the general secretary of so-and-so labor union is a protected workman under the Industrial Disputes Act. The order of transfer clearly amounted to an act of unfair labor practice. But the management side did not pay any heed to the objection raised by the petitioner and illegally withdrew the token card of the petitioner workman and also restrained him from joining his duty WEF 51/2005. Poster. The petitioner, so management side had issued a letter on 5/1/2005 in the name of the petitioner, now addressed to the petitioner, whereby the petitioner was sought to be informed that he stood released from the close of working hours of 27/12/2004 in order to enable him to undertake the journey on 28/12/2004. So as the petitioner neither collected a ticket nor he had reported for duty at Kunur, the management side advised the petitioner to report for duty immediately at the transferred place. Poster. Stating that the petitioner had forcibly entered into the factory premises of Messrs. Steelwash Private Limited and marked his attendance and tried to do some work forcefully, the management side informed the petitioner that his entries on those dates were unauthorized and it would have no effect unauthorized. Full stop. Fair. After issuance of the letter dated 5/1/2005, the petitioner approached the Assistant Labor Commissioner, Dibrugarh, seeking intervention into the matter of intervention into the matter, and the Assistant Labor Commissioner,
Tinsukia, I'm sorry.
Tinsukia, taking cognizance of the taking cognizance on the allegation made by the petitioner, issued a letter on 5/1/2005 to the management of Messrs Steelworks Private Limited, Tinsukia, whereby request was made to withdraw the transfer order issued to the petitioner and to allow him to undergo his normal works for the time being with immediate effect till conclusion of the conciliation proceedings, as the petitioner is a protected workman under the provisions of the Industrial Disputes Act 1947. Also, para. Issuance of the letter dated 5/1/2005 of the Assistant Labor Commissioner, Tinsukia, had led the management side to prefer a writ petition, WBC number 1455/2005 before this court. Full stop. The petitioner was impleaded as party respondent number 5 in the writ petition WPC number 1455/2005. Full stop. তার আগতে Twelve one 2005. Where is that letter? Two other letters have been challenged.
In the petition, page number,
Not there. There.
my lord, yes, my lord, he opposed that.
Okay. Mm. The letter dated 5/1/2005 of the Assistant Labor Commissioner Tinsukia was followed by another letter dated 12/1/2005, whereby we should followed by a show cause notice dated 12/1/2005 from the Assistant Labor Commissioner Tinsukia, whereby the management of Messrs. So-and-so was asked to show cause as to why necessary steps for prosecution should not be taken Full stop. Then again 24/1. What is that 24/1? Not part of LCR. Twenty-four-one.
If for one, it is an extra.
The petition was challenged. The petition challenged show cause notices.
My lord, as per my lord, may I take leave, my lord?
And wait, let me concentrate. Show cause notices করে দিব, comma dated 12/1/2005 and dated 24/1/2005. তাৰপিছত একেখিনি থাকিব। Issuance of the show cause notices, comma dated 12/1/2005 and dated 24/01/2005 had led the management of so and so. এইখিনি লিখিলো ন? এইখিনি ঠিকে আছে। It was contended on behalf of the management side that the petitioner was not a protected workman. And as such, comma, he was not entitled to any protection during the pendency of the conciliation proceedings. Full stop. It was argued from the workman's side that the petitioner, being a protected workman, comma, would be entitled to the protection provided to such protect government under the Industrial Disputes Act 1947. Full stop. Observing that the so-called notices were founded on, no, it was observed that whether the so-called notices were founded on any legal premises, comma, would be a jurisdictional issue, comma, which can be urged by the management side in response to the so-called notices. And all such issues could be adjudicated by the authority who had issued the so-called notices. Full stop. It was observed that the authority issuing the so-called notices, comma, being a statutory functionary, are constituted under the Industrial Disputes Act 1947, comma, such authority should be allowed to decide the matter. With such observations, comma, the learned single judge had decided not to entertain the writ petition. Full stop. By holding that the writ petition was not maintainable on a being premature, comma, was not maintainable, comma, the writ petition was dismissed by an order dated 2/3/2005. Full stop. It was further observed that the Assistant Labor Commissioner, comma, Tinsukia, should try to finalize the conciliation proceedings expeditiously. Full stop. Where the aggrieved, being aggrieved and dissatisfied by the observation made by the learned single judge in the judgment and order dated 2/3/2005 in the writ petition WPC number so and so, the management side preferred an intra-court appeal, comma, writ appeal number 287/2005. Full stop. It was contended before the writ appellate court that the management side was not challenging the validity of the order dismissing the writ petition, but it was full stop. It was further contended that the observations made in paragraph 10 in the judgment and order dated so and so, the alliance single judge had observed that the petitioner, being the general secretary of the workmen union, comma, would be a protected workman, is not based on facts. Full stop. The writ appeal was dismissed by an order dated 3/6/2005 with the observation that the learned single judge had already clarified that all issues pertaining to merit had to be gone into by the authority concerned irrespective of the observations made. Before the learned industrial tribunal sorry, on receipt of the on receipt of the reference forwarded to the learned industrial tribunal, Dibrugarh, Dibrugarh, by the notification dated 11/11/2008, comma, the learned industrial tribunal registered the same as reference case number 4/2008 and notices were issued to both the sides to file their written statements with documents. Notices were issued, comma, on 29/12/2008, comma, to both the sides to file their written statements with documents. Full stop. The workman side, the workman submitted his written statement on 2/1/2010. While the management side submitted its written statement on 13/8/2010. Full stop. Any witness was
The workman, one witness.
during the proceedings, in the course of the proceedings, comma, the workman, i.e. the petitioner, submitted his evidence on affidavit and he was duly cross-examined on 30/4/2012 and he was duly cross-examined by the management side on 14/5/2012. Full stop. From the management side, one Sri Baldev Singh, personal manager, Messrs Steelworks Private Limited, Tinsukia, adduced his evidence on affidavit on 10/9/2012 and he was cross-examined by the workman side on 10/10/2012. Full stop. During the with their testimonies, so sorry, the workman had exhibited 14 number of documents and the management witness exhibited 11 number of documents. Full stop. Para. After appreciation of the oral evidence as well as the documentary evidence, the learned industrial tribunal had passed the award dated 20/10/2012, deciding the first issue of the reference against the workman. Full stop. As the second issue of the reference was dependent on an affirmative was dependent on the outcome of the first issue, the learned trial court, in view of the second issue, had also gone against the workman in view of the decision rendered on the first issue in favor of the management side. Full stop. The learned industrial tribunal had negated the contention advanced by the workman that he was a protected workman under the Industrial Disputes Act 1947. Full stop. The learned industrial tribunal had also observed that the workman had committed misconduct by not following the order of the management, by defying the order of transfer. Full stop. It was observed by the Learned Industrial Tribunal that the transfer, being a condition of service, comma, the management side had the authority to transfer an employee in their factory to other place, and the same and the management side had the prerogative to transfer an employee. First. The Learned Industrial Tribunal had also negated the challenge that the management side had resorted to any unfair what is the form? Unfair labor practice in transferring the petitioner. And a refusal on the part of the workman to join duty at his transfer place would not justify the act of the petitioner, act of the workman. Full stop. Deciding the issues against the workman in the aforestated manner, comma, the impugned award has been passed. Full stop. Para. I have heard MS A. Bhattacharya, Learned Counsel for the petitioner, Mr. S. Somoria, Learned Counsel for the respondent number 1. Full stop. MS Bhattacharya, Learned Counsel for the petitioner, has strenuously contended that it was during the course of an ongoing conciliation proceedings, comma, the petitioner, who was the General Secretary of so-and-so union, was transferred by the impugned order dated 27/11/2004. Full stop. When the management side was informed duly that he, being the General Secretary of the so-and-so union, of the recognized of the so-and-so union, comma, a recognized workman union, a union recognized by the management, comma, and was taking part in the 10 ongoing conciliation proceedings before the Assistant Labor Commissioner, Tinsukia, espousing the causes of the workmen, comma, and thus, comma, was entitled to the privileges available to a protected workman. The management side adopting a vindictive attitude did not pay any heed and had proceeded to adopt the unfair labor practice of stopping the petitioner from working in the which place? Originally you were working where?
Tinsukia.
Factory of Messrs. So and so, Steelworks so and so, located at Tinsukia with effect from 5/1/2005. Full stop. MS Bhattacharya has referred to a letter dated 27/4/2005 comma annexed to an affidavit, additional affidavit filed, brought on record today. When did you file?
Yesterday, yesterday morning.
Brought on record today, to urge that by the letter dated 27/4/2005, comma, the management side was given a list of protected workmen under the signature and seal of the petitioner in his capacity as the General Secretary of Messrs. Steelworks Workers Union. And the said letter was duly received by the management side on 29/4/2005. Full stop. With the Messrs. Steelworks Worker Union being a recognized union of Messrs. Steelworks Private Limited and a list of protected workmen had already been received by the management. List of protected workmen dated 27/4/2005, comma, was already received by the management on 29/4/2005, comma, the petitioner is clearly entitled to the privilege available to a workman, a protected workman under subsection 3 of section 33 of the Industrial Disputes Act. Full stop. Any other contention?
The petition made for this. Because he being a protected workman.
Hmm?
Being a protected workman, service condition of his may not be changed.
It is contended that by the order of transfer dated 27/4/2004, comma, the management side had clearly altered the conditions of service of the petitioner. And the same is clearly impermissible in law. Full stop.
And I am protected under section 33, rule 3 and 4. That may be observed.
It is submitted that the provisions of subsection 3 of section 33 is to be read conjointly with the provisions of subsection 4 of section 34 of the Industrial Disputes Act. Anything? Further drawn attention to the show cause notices, to the letter dated 5/1/2005, as well as the show cause notices, dated so and so and dated so and so, of the Assistant Labor Commissioner, Tinsukia, wherein he had clearly observed that the petitioner, being a protected workman under the Industrial Disputes Act 1947, an order of transfer like the one involved here should be withdrawn. Yes, this was
And my lord, you already make a mention of rule 64 of Assam Labor and Industry.
and full stop. To draw support for such a submission, reference has been made to Rule 64 of the Assam Industrial Disputes Rule 1958.
Sub-rule 4.
Rule 54,
60.
more particularly, Sub-rule 4, care of. Full stop, all contrary, all contrary, Mr. Shomoria, learned counsel appearing for the respondent number 1, has submitted that the division bench in its order dated 3/6/2005, passed in read appeal number 287/2005, had clearly clarified that all issues pertaining to merits had to be gone into by the authority concerned, irrespective of the observations made. And the learned industrial tribunal had accordingly, appreciated the evidence laid by both the sides before it during the proceedings of reference case number so and so, and had correctly observed that the petitioner was not a protected workman, full stop. It is his submission that being the General Secretary of the recognized trade union, workman union, is not the sole criteria to enjoy the privilege of the protected workmen under the Industrial Disputes Act 1947. Full stop. it is his further contention that taking part in the then ongoing conciliation proceedings would not give the petitioner the privilege of protected workman. Full stop. Referring to the letter of appointment dated 1/11 to 1986, he has contended that the transfer is a condition of service of the petitioner, and as per the said letter of appointment, the petitioner was liable to be transferred from one place to another or from his present place of posting to a sister concern, whether in existence or which might come into existence at a later point of time. Full stop. The matter, the dispute for which the conciliation proceedings was then going on was not connected with an order of transfer, and there was no alteration of the conditions of service applicable to the petitioner immediately before the conciliation of before the commencement of such conciliation proceedings. Full stop. With as there was no recognition of the petitioner as a protected workman under the provisions of subsection 3 of section 33. Read with Rule 64 of the Assam Industrial Disputes Rules, 1954, the petitioner was not a protected workman, and the learned industrial tribunal had correctly arrived at a finding that there was no ground to hold that the petitioner was a protected workman without any recognition from the management side. Full stop. As the findings of the learned industrial tribunal is not perverse and has been reached on the basis of evidence adduced during the proceedings before it, the certiorari jurisdiction is not available to be exercised to dislodge a finding which is not perverse. So stop. In support of his submissions that এই দুটা হেৰি লাগিব হে এইকেইটা মই পঢ়িব নোৱাৰিব দিগদাৰ হয় অনুপাত্ৰ মই একদম নোৱাৰো পঢ়িব এইটো আনি দিব লাগিব আৰু এছএছচি আছে নাই এছএছচি decisions of the Honorable Supreme Court of India in P.H. Koilani versus Air France Calcutta, reported in AIR 1963 SC 1756, para 5 লিখি দিব and Air India Corporation, Bombay versus V.A. Revelo and others, reported in 1972, 1 SSC 814. I have given due consideration to the submissions, rival submissions made by the Learned Council for the parties, and have also perused the materials brought on record by the parties through their pleadings. I have also gone through the materials of a case record of reference case number 01/2012, in original as the same was requisitioned by an order dated 4/3/2005. Full stop. At this stage, it is apposite to observe that when the petition was moved on 4/3/2013, this court had after carefully considering the order of transfer dated 27/11/2004 and the relevant portion and the award dated 20/12/2012, had observed that no interference was called for at that stage as an interim measure. It was made clear that if the petitioner carried out the transfer order in terms of the order of transfer dated 27/11/2004 and subsequent order dated 3/1/2013, the question of regularization of the service of the petitioner from the date of transfer till his date of joining at his new place of posting would be taken up for consideration by the court. Did you join? No. As it has emerged from the rival submissions, as the rival submissions have been made, by referring to the provisions of Section 33 of the Industrial Disputes Act 1947, comma, it is apposite to quote the provisions of section 33 in its entirety herein below. 33. Para. It is by a notice of conciliation dated 19/10/2004. Comma, exhibited as Exhibit 5 by the workman. Notice of conciliation issued by the Assistant Labor Commissioner Tinsukia as the conciliation officer Tinsukia, comma, exhibited as Exhibit 5 by the workman, comma, notices were issued to both the sides dash the management of Steelworks Private Limited Tinsukia and the workmen represented by the General Secretary, comma, Steelworks Workers Union Tinsukia dash under Section 4 of the Industrial Disputes Act 1947 that conciliation would be held on 26/10/2004 as an industrial dispute had existed stroke was apprehended between the two sides on bonus for the accounting year colon 2003-2004. Full stop. The issue of bonus for the accounting year 2003, 2004 was taken up in conciliation proceedings held on 26/10/2004. And views were recorded, views from both the sides were recorded in the minutes of the conciliation proceedings. Issued on 2/12/2004. Full stop. As per the minutes of the conciliation proceedings issued on 2/12/2004, the settlement could not be arrived at on the issue of bonus for the accounting year 2003/2004, and the conciliation officer scheduled another round of conciliation on 15/12/2004 to explore possible settlement on the issue. Full stop. The minutes of the conciliation proceedings issued on 28/12/2004 had observed that the conciliation proceedings had failed as the parties could not arrive at any settlement. Full stop. Thus, there is no dispute to the fact that a conciliation proceedings was going on and from 26/10/2004 on the issue of bonus for the accounting year 2003/2004, and such conciliation proceedings concluded on with failure, as recorded in the minutes of the meeting of the conciliation proceedings issued on 28/12/2004. Full stop. On a reading of subsection 1 of section 33 of the Industrial Disputes Act, comma, it emerges that it entirely emerges that during the pendency of any conciliation proceeding before a conciliation officer in respect of an industrial dispute, comma, no employer within bracket small a in regard to any matter in italics connected with the dispute, comma, alter, comma, to the prejudice of the workmen concerned in such dispute, comma, the conditions of service applicable to them immediately before the commencement of such proceeding, colon, 33 1 of F, or B, for any misconduct connected with the dispute, comma, discharge or punish, comma, whether by dismissal or otherwise, comma, any workman concerned in such dispute, comma, save with the express permission in writing of the authority before which the proceeding is pending. Full stop. Does an employer during the pendency of the conciliation proceedings before a conciliation officer, comma, is prohibited from altering the conditions of service of the workman, colon, or Roman 1, after Roman 2, dismissing or discharging or punishing the workman in respect of, comma, in respect of, quote, any matter or misconduct connected with the dispute, unquote, save with the express permission in writing of the authority before which the proceeding is pending. Full stop. The in subsection 1 of section 33, comma, the emphasis is sorry, no, the prerequisite is in order to attract the restriction on the employer, comma, the dispute, the industrial dispute before the conciliation officer has to be connected with the dispute. Full stop. Para. Subsection, the provisions of the restriction under subsection 2, subsection 33 is attracted when no, as per subsection 2 of section 33, comma, during the pendency of any conciliation proceeding as referred to in subsection 1, comma, no, during the pendency of any conciliation proceeding in respect of an industrial dispute, comma, as referred to in subsection 1, comma, the employer may, in accordance with standing orders applicable to a workman concerned in such dispute, or where there are no such standing orders, comma, in accordance with the terms of the contract, comma, whether express or implied, between him and the workman, A, alter, comma, in regard to any matter not connected with the dispute, comma, the conditions of service applicable to that workman immediately before the commencement of such proceeding, colon, or B, for any misconduct not connected with the dispute, comma, discharge or punish, comma, whether by dismissal or otherwise, comma, that workman. Full stop. The proviso to subsection 2 has provided that no such workman shall be discharged or dismissed, comma, unless he has been paid wages for 1 month and an application has been made by the employer to the authority before which the proceeding is pending for approval of the action taken by the employer. Full stop. Para. The conciliation, at the time when the order of transfer dated 27/11/2004 was made, comma, the conciliation proceeding which was going on at that point of time was in respect of bonus for the accounting year, colon, 2003-2004. Full stop. The order of transfer dated dated so and so, transferring the petitioner to Kunur, Tamil Nadu, was not connected with the dispute for which the conciliation proceeding was, comma, at that point of time, comma, was going on. Full stop. As such, comma, there is the provisions of subsection 1 of section 33 is not found attracted or applicable in the case in hand. Full stop. Para. Before the Learned Industrial Tribunal. Comma. The management side went by the workman. What is it? 111. A letter of appointment. Management side not again. A letter of appointment. Both dated 1/11/1986. Letter of appointment of the petitioner. Dated 1/11/2086 was exhibited. Full stop. An appointment letter dated 2/11/1985. Appointment letter of the petitioner dated so and so was also exhibited. Full stop. Para. As per the letter or letter of appointment dated 1/11/1986, comma. In the letter of appointment dated so and so, comma, the reference of the earlier letter dated 2/11/1985 was made and stop. And in reference to the said letter dated 2/11/1985, comma, the petitioner was appointed. No, so, sorry. Sorry, the letter of appointment dated 1/11/1986 had referred that by the earlier letter of appointment dated 2/11/1985, the company had appointed the petitioner as a temporary helper. Full stop. By the letter of appointment, the petitioner's services and appointment had been confirmed with effect from WEF 2/11/1986 on the same pay scale stroke emoluments, subject to the conditions of service and the standing order in force. Full stop. As per clause 3 of the letter of appointment dated 1/11/1986, the petitioner's place of posting would be at that point of time, at Tinsukia, but he was liable to be transferred to another branch, shift, post, or place, or to sister concern, whether in existence or which might come into existence thereafter. Full stop. Clause 3 had further observed, had also had set forth that the management can shift the places of working anywhere in India, and in that event, the petitioner had to make compliance for working at the new place of work. Full stop. It was further laid down that the management can shift the premises anywhere in India, and the petitioner had to report for work at the shifted place. Full stop. From in various letters issued under the order of transfer dated 27/11/2004. That is, letter dated 7/12/2004, letter dated 9/12/2004, etc. It was quoted that the standing order of Messrs. Steelworth Private Limited, then in force, had the condition, quote unquote, refusal to accept transfer from one shift to another shift, or from one section or department to another, page 102, or from one place to another, whether locally or out of station, or from one establishment to another establishment under the same management, unquote, shall be treated as a major misdemeanor for which the workman is liable to dismissal. Where reference is to be made to also to section 9A of the Industrial Disputes Act, which states as under 9A. 9A as well as schedule. As well as the fourth schedule of the Industrial Disputes Act, which read as under. Here, 29 page 9A was a RO 116 or 4 It does, it has thus from the provisions or from the conditions included in the letter of appointment dated 1/11/1986 from the provisions quoted from the standing order of Messrs. So and so, then in force, comma, it has clearly emerged that the transfer from one where the petitioner or from the place where the petitioner was working on either at the time of initiation of the conciliation proceedings or at the time of issuance of the order of transfer, initiation of transfer 26/10/2004, and at the time of issuance of the order of transfer dated 27/11/2004, the transfer from one place, from the place where the petitioner was working to the place at Kunur, Tamil Nadu, was permissible under the terms of the contract as well as per the standing orders applicable to the petitioner concerned. Full stop. In such view of the matter, comma, this court does not find that the provisions, full stop, neither in section 9A nor in fourth schedule, comma, the matter of transfer has been incorporated, has been included as a condition of service, for change of which notice is to be given in terms thereof. Full stop. In such view of the matter, comma, this court does not find is of the considered view that the provisions of subsection 2 of section 33 is not attracted in a case in hand. Full stop. Para. The above discussion, the matter which is left for consideration now is whether the petition is a protected workman as per under the provisions of subsection 3 of section 33 of the ID Act. Full stop. Subsection 3 starts with a non-obstante clause. In reference to subsection 2. Full stop. As has already been observed above, comma, the provisions of subsection 2 of section 33 is not found applicable in the case in hand. Full stop. It is full stop. Thus, comma, no, full stop. According to subsection 3, comma, no employer shall, during the pendency of any conciliation proceeding in respect of an industrial dispute, comma, take any action against any protected workman concerned with such dispute, A, by altering, comma, to the prejudice of such protected workman, comma, the conditions of service applicable to him immediately before the commencement of such proceeding, colon, or B, by discharging or punishing, whether by dismissal or otherwise, comma, such protected workmen, comma, except with the express permission in writing of the authority before which the proceeding is pending. Full stop. Explanation to subsection 2 has provided that has explained the definition of quote unquote protected workman, full stop. A, quote, protected workman, comma, in relation to an establishment, comma, means a workman who, comma, being a member of the executive or other office bearer of a registered trade union connected with the establishment, comma, is recognized as such in accordance with rules made in this behalf. Full stop. It is not in doubt that the steelworks, it is not in dispute that Messrs. Steelwork Workers Union is a union recognized by the management of Messrs. Steelwork Private Limited. Full stop. From the minutes of the conciliation proceedings, comma, exhibited before the learned industrial tribunal, comma, it is noticed that the petitioner as the secretary of Steelwork Workers Union took part in the conciliation proceedings for espousing the cause of the workmen with regard to the dispute relating to bonus for the accounting year, colon 2003-2004. Full stop. Messrs. Steelwork so-and-so Workers Union is also the registered trade union connected with the establishment of Messrs. Steelworks Private Limited. Full stop. Satisfaction, fulfillment of the above conditions are in addition to fulfillment of the above requirement, comma, it is also the statute has provided that to be recognized as a protected workman, comma, a workman has to be recognized as such in accordance with rules made in that behalf. Full stop. Insofar as the establishment involved here, comma, the appropriate government, quote unquote, comma, as per section 2 within bracket A of the Industrial Disputes Act, comma, is the state government. State government? Full stop. In such view of the matter, comma, the rules the provisions contained in the rules, comma, quote, the Assam Industrial Disputes Rules 1958, comma, framed in exercise of the powers applicable are applicable, full stop. The rule 64 of the G2 Namdier has provided for the matter of protected workmen, and it raises under 64. So many provisions are involved. That is why it appears that this repetition is pending since 2013. Yes, Mr. Pathak, anything?
Number 10.
Top of the list. We'll see to that next.
May I please your
Let me finish this.
May I please your lordship, I want to mention item number.
There is one arbitration, right? Arbitration petition. Okay, we'll pass the order after the top of the list.
Your lordship, I beg to mention item number 7, kindly pass for the day.
7. We don't know who will be able to reach. 7. Yes, this is bail.
And I order
I order. Yes.
today.
What is there?
Today my senior health condition and my health condition very bad.
Both have fallen sick. Okay.
Order 7, kindly pass over this item.
What is this matter? What is this matter? Bail?
I criminal 121/2020.
What is for? You don't know.
Respondent.
You are for respondent. Where is the petitioner?
I'm the petitioner. Actually, I filed this I for cancellation of the bail.
Cancellation of the bail
Yes, lordship. For violation of the honor report.
or violation. Search is submitted.
Oh, yes,
Search is submitted.
yes,
Anticipatory bail granted.
Yes.
Search is submitted. Did he appear before the trial court?
oh, I have no information. Just last.
Or is
question.
PP? No. Yes, Mr. Nath. I think you have a matter. I don't think we will be able to reach that. There is another top of the list. Pathak.
Item 2. Another day or
Your item 2018.
May I
You
please-
can wait for a month or two.
May I please your lordship? Lordship is
Lordship,
item number.
Lordship, kindly pass over this matter item.
Okay,
Yes, sir.
join prayer.
And I have no, I have no objection. If
We have take the consent
Okay.
of leisure.
Wait, your name please.
Zeta Muli.
Z. Tamuli,
Lordship.
Learned Counsel appearing for?
for the response.
M.
You don't
Islam.
know, huh?
M. Islam. Or respondent.
Appearing for M. Islam Learned Counsel for respond number 1 has paid for a listing of the case after a week on the ground that Mr. M. Islam is indisposed. Full stop. MSJ Paul, learned counsel for the applicant. Considering the ground cited for adjournment, comma, has agreed to the prayer. Full stop. The prayer made by MS so-and-so is allowed, is that case after we're gonna date with explain.
The date will take.
First week of October.
Then after vacation.
Okay, we'll try to find out a date after consulting court master.
May I-
File over. We don't know.
May I please your lordship?
Alright.
Lordship, in item number 4, similar matters were listed in code 5. Lordship, as per the last order of this court, this matter was also to be tagged along with that matters. Lordship may fix this matter on 26/9.
26/9.
Yes, Lordship.
MS.
The matter may be tagged.
Okay, we'll come and see the record and pass the order to.
Lordship. Tagged along with WPC 1545 of 2022.
What happened? All those matters are listed today.
Yes, Lordship, in code 5. It was
And what
listed.
happened?
And government took time
Okay,
for the records.
okay.
Lordship, so this matter
Ami
is
MSG Swami,
Yes, Lordship.
learned counsel for the petition, has submitted that. Has submitted that this petition be listed along with 3 other petitions, comma, WPC number 1545/2022, comma, WPC number 1691/2022, and WPC number 1696/2022, comma, involving similar issues, comma, which are ordered to be listed on 26/9/2023. Stop. As paid for Mr. Which council, state council, anybody? As paid for, comma, please this petition along with so and so on 26/9.
Obliged.
Item 3, the matter was heard, my lord, but for order to be passed.
I don't
Yeah,
know
yeah.
whether it is possible today. There is another top of the list category.
Yes, ma'am.
Item 10. Yes, that fishery matter.
Yes, please, very much.
Somebody else then. The division bench, right? Division bench
Yes,
order,
ma'am.
something
Yes,
like that.
yes, yes.
Okay. Yes, tell me on which date you want.
Next Tuesday, madam.
Next Tuesday, possible. ठीक है sir, next Tuesday. As sought for by Mr. Ascount and a council for the petition, list the case on next Tuesday. Gimana then? I don't know if top of the list comes.
Yes, ma'am.
Before your lordship starts, my lord, I want to submit, my lord. My lord, I reiterate what I have submitted, my lord. I reiterate. But I want to point out, my lord, in tea industry and in other industries in Assam, my lord, it is a custom, my lord, to declare the office bearer, that is the General Secretary President, as a protected workman, my lord. That is the
Oh, what is the
custom.
custom? I do. You should have brought it on record.
No, it is on record, but so from my instruction is that, my lord. Otherwise, my lord, there will be great problem in the whole industry, my lord.
No, but we don't know about the. We only want to see whether this law is applicable or not. Industrial Disputes Act 33 rules, industrial dispute rules.
And
We'll all only go by the records.
I just want to point out, my lord, it is a custom so far my instruction is concerned. I got the instruction. And on that, my lord, I will take your lordship to Article 13 of Constitution of India. That is, it says.
That
my
has to
lord,
be recognized. You have not brought it. The custom is to be 13. Article 13 has to be praised.
Yes.
You have
custom
to
is a
show it.
part, the law. But on record.
But
my lord,
records, neither we are only on the issue certiorari. We are on certiorari, right? We have to see whether the tribunal has transgressed its jurisdiction or not. We cannot add to it or we cannot.
But my lord, So far, my
Law is
instruction-
settled.
The law is settled, but custom is going on, my lord, like that, my lord. In every industry, in every tea garden, my lord. The general secretary and.
No, you have to you take the recourse of other remedies available against my order.
And, no, my lord, that's why I
This,
point out. on
this is not because whatever is on record, we can only traverse that. We can only travel that, nothing beyond that.
And may I say in that case, my lord, people also make a observation that this is applicable only to this matter. It may not generally, that observation some may be there. my lord.
What
Otherwise, it will-
observation?
That it is applicable in this matter only, my lord.
I cannot do so.
Otherwise, my lord, there will be.
If I
clear-
grant concession for a special case, I could have done so. But if the law is what the Supreme Court also says,
That is, yeah, my lord. but the
one
custom is
Supreme
there,
Court
my
is saying, how can I say that these observations are limited to this case only?
my lord. I mean, because of my instruction, because custom. it is a
Instruction,
custom.
now tell me, MS
That is what
Prasad ji,
going on in the tea industry, my lord. It
what
is
is going on, we cannot take cognizance of. So many things are going on.
It is a custom, my lord, for years together, my lord. That's what I point out, my lord.
Then tribunal has held, we are only deciding the tribunal case. Such a jurisdiction, how can we travel?
And you're also when this white power, my lord. In your observation, your lordship may keep.
It
Your
is
lordship
difficult
Is extra.
I have,
jurisdiction, your lordship
because I
applies.
have heard you, now.
No,
Now
I
at
did-
this
I
fig
did-
end, when the order is being dictated, how can I
did that, why I have.
take
what-
cognizance of something which is not on record?
No, I did that, what I have submitted, my lord.
I haven't recorded, I have asked you that these are your submissions.
Yes. But.
Whether these are your submissions, I have asked you, I have paused, I have recorded whatever you have said.
Right now, I have got the instruction that is the custom going on, my lord.
We are only deciding stoppage of work.
That's
Right.
why I submit
That
my-
issue of MS Parasaji issue whether this kind of stoppage of work leads to dismissal or not, that we are not deciding. Because the reference is what? Justified or not justified? Now tribunal has held that he has defied the orders of transfer.
I don't, in that, may I submit that, that may be limited to this matter only, my lord, regarding.
I will record that one line that this is a custom going on.
This is a custom going on and as per Article 13(3), my lord.
13.3 will not just for the sake of making submission will not come into picture.
That's true.
Without any iota of materials on record,
That's true, my lord. Because
then I can only record your
right
submission.
now, I oral,
I can only now, and after 10 years, it is not possible. Am I clear? After 10 years,
yes, I understand.
I
sir.
should not have admitted your affidavit in opposition also. Without leave that has been submitted. Still, I have
I apply.
taken cognizance of.
Applies for that, my
Now
lord.
it is very difficult.
Some observation regarding.
See the predicament of the court also,
That I have observed, my lord.
which you have not brought on record in any manner whatsoever. How can I observe something?
My submission.
This
may be-
is for a seasoned counsel like you, it could not have been a
I
submission.
am, because right now I have got the instruction, my lord. So I leave it to a lordship, my lord.
64 কোট করে দিছে না sub rule 1 of Rule 64 has provided that every registered trade union connected with an industrial establishment, to which the Industrial Dispute Act applies, shall communicate to the employer before the 30th September every year. The names and addresses of such of the officers of the union who are employed in that establishment and who, in the opinion of the union, should be recognized as, quote, protected workmen, unquote. Full stop. In the case in hand, additional affidavit. Additional value court. The petitioner has claimed that by the letter dated 27/4/2005, which was issued under his hand in the capacity of General Secretary, Steelworks Workers Union, in the letter by the letter claimed it by the letter, the names of 6 office bearers of Steelworks Workers Union have been mentioned, were mentioned to the management to recognize them as protected workmen. Full stop. Amongst the 6 office bearers of Steelworks Workers Union, the name of the petitioner was also included as the General Secretary of Steelworks Workers Association. Full stop. The said letter dated 27/4/2005 was received by the management on 29/4/2005. Full stop. But from sub-rule 2 of Rule 33, it is evident that mere communication of the names and addresses of the office bearers of the registered trade union connected with the establishment mere communication as to recognize them as recognized workmen would not make the listed person as recognized workmen. Full stop. Sub-rule 6(2) of Rule 33 has specifically prescribed that the employer has to recognize such workmen to be quote unquote protected workmen for the purpose of subsection 3 of section 33 and communicate the same said decision to the union, comma, in writing, comma, within 15 days from the date of receipt of the names and the addresses under sub-rule 1, comma, the list of workmen recognized as protected workmen. Full stop. A question would definitely arise in such situation, comma, whether in the absence of any communication from the management side in writing within 15 days from the date of receipt of the names and addresses of the office bearers of the union whom the union seeks to be recognized as workmen would give those workmen the recognition as protected workmen. Full stop. There is no deeming provision in Rule 64 of the Assam Industrial Dispute Rules 1958 that to the effect that in the event, comma, the employer does not communicate to the union comma, in writing, comma, within the stipulated period of 15 days, that the workmen, names of which were forwarded to it, comma, have been recognized as protected workmen, they would be deemed as protected workmen on expiry of 15 days from the date of such communication. First of that in the event the management or employer does not recognize such workmen as protected workmen, then the recourse that is available for the union is to raise a dispute before the labor commissioner, before the appropriate authority under, that is, Labor Commissioner, Assam, in terms of sub-rule 4 of Rule 64. Full stop. Sub-rule 4, Rule 64 of Rule 64 has prescribed that when a dispute arises between an employer and any registered trade union in any matter connected with the recognition of quote unquote protected workmen under the Industrial Disputes Act, the dispute shall have to be referred to the Labor Commissioner, Assam, and it is the Labor Commissioner whose decision, Labor Commissioner, Assam, whose decision thereon shall be final. Full stop. the tribunal, the learned industrial tribunal, has in its award has observed that no, before the learned industrial tribunal, it was canvassed on behalf of the management side that in the absence of recognition from the management side, recognition to in the absence of recognition to the petitioner as a protected workman from the management side, the petitioner could not be regarded as a protected workman. Full stop. In the absence of any such recognition to the petitioner as a protected workman, there was no question of taking permission from the labor department in writing before transferring a workman who is not a protected workman. Full stop. The learned industrial tribunal had observed that no letter was proved from the workman union to show that they were the petitioner was a protected workman, and as such, there is no reason to hold that the petitioner is a protected workman in the absence of any declaration from the management side. ফুটবল এই হেৰিৰ ডিচিশন কেইটা সমনীয়াৰ ডিচিশন কেইটা অহা নাই নেকি অহা নাই in the Honorable Supreme Court of India, in the case of P.H. Kalyani versus Air France Calcutta, reported in AR 1983 SC 1756, has observed as under paragraph 5. Paragraph 5. Paragraph 8. We should, okay. In 8. The Honorable Supreme Court of India in Air India Corporation Bombay versus so and so reported in 1972 1 SSC 814 after referring to the provisions of section 33 of the Industrial Dispute Act has observed as follows. Has observed as under. Here are 10. In the backdrop of the above fact situation, comma, it is, and more particularly in the absence of any recognition to the petitioner as a protected workman, it is to be seen whether the learned industrial tribunal it is to be seen how the industrial tribunal had decided the first issue in the reference. Full stop. The learned industrial tribunal had discussed the evidence, oral evidence, as well as the documentary evidence laid before it by both the sides. Full stop. reference. It had referred to Exhibit 1, page 36, okay. Appointment letter dated 2/11/1985. Exhibit 2, certificate of the management. Amongst other, had referred to Exhibit 1, underlined position. Exhibit 14. It had referred to the documentary evidence laid by the workman, namely is 36 also 1 to 14, and the documentary evidence laid by the management side. Exhibit A, Exhibit B, Exhibit KLOS. Full stop. It had, the Learned Tribunal had noted the fact that the petitioner joined the employer in the year 1985. Full stop. The fact of pendency of the conciliation proceeding at the time of issuance of the order of transfer dated 27/11/2004 of the petitioner to Kunur, Tamil Nadu, wherein another factory of the employer was in existence, was also taken note of. Full stop. By the order of transfer, the petitioner was requested to join his transfer place of posting at Konur, Tamil Nadu, with effect from 15/12/2004. As the petitioner did not act in terms of the order of transfer, the period, the tribunal had also noted that as the petitioner did not join his transfer place of posting pursuant to the transfer order, the management side extended the period of joining at the new assignment. Full stop. In support of the fact of extension to join the period of extension of the period to join the new place transferred place of posting, the Learned Tribunal has observed that the management side had proved the same by documentary evidence. The documents, the documents, the exhibited documents am available in the case record of reference case number so and so. Go to indicate that after issuance of the order of transfer dated 27/11/2004, the petition submitted a letter on 6/12/2004 claiming that his post, his job was not a transferable one as per the terms and conditions, and the employer could not enforce him to go and join the new place of posting. Full stop. But the said claim of the petitioner is belied by the terms and conditions of the letter of appointment dated, his letter of appointment dated 1/11/1986, which is a part of the case record and which bears his signature with a declaration that he had read and understood the terms and conditions, which include the clause of transfer, which permitted the employer to transfer him from one branch from his from the place of posting at Tinsukia to another branch, or to another place, or to a cistern concern, or anywhere, or any place or places of working anywhere in India. Full stop. The claim that though in the said letter dated 6/12/2004, the petitioner had claimed that he, being the General Secretary of Steelworks Worker Limited, was a protected workman, the said claim, in view of the discussion made above, in view of the observation made by the Learned Industrial Tribunal, and also in view of the discussion made above, is found to be misplaced. Full stop. By letters dated 7/12/2004 and dated 9/12/2004, the petitioner was informed that his refusal to join at Kunur would tantamount to major misconduct as defined in standing order then in force in Messrs. Steelworks Private Limited, as the standing order had stipulated that refusal to accept transfer from one shift to another shift, or from one section or department to another, or from one place to another, whether locally or out of station, or from one establishment to another establishment under the same management, would be treated as a major misdemeanor for which the workman would be liable to be dismissed. Full stop. The said letters, dated 7/12/2004 and dated 9/12/2004, had further mentioned that the railway ticket reserved railway ticket from Tinsukia to Coimbatore had already been booked, and the same had to be collected by the petitioner from the concerned section well in advance. Full stop. By letters dated 7/12/2004, by another set of letters dated 7/12/2004 and dated 9/12/2004, comma, the management had extended the time period for joining the duty at Kunur to 1/1/2005. Full stop. The endorsements in those letters with signatures of a number of persons had indicated that the petitioner refused to accept those letters when those were tendered to him. Full stop. The evidence on the materials on record further indicated that those letters were also forwarded to him, sent to him by a registered post to the petitioner at his address at token number 107/38, quarter number C-9- and Roman ends, that C-10, Steelworks Workers Colony. Full stop. The materials on record also include copies of rail tickets to Kunnur, reserved railway tickets to Kunnur, reserved railway ticket and its cancellations and their cancellations. Full stop. The materials on record also include the registered postal articles bearing endorsement that those registered articles sent to the address of the petitioner was refused with the endorsement of the postal department, was refused when tendered on a number of times. Full stop. The letter dated 5/1/2005, comma, the management informed the petitioner to the effect that when the petitioner was advised to collect the railway ticket on 7/12/2004 in order to enable him to report for duty on 15/12/2004, comma, the said instruction, the petitioner refused to collect the railway ticket. Full stop. When, as per the request of the petitioner, comma, the date of joining was extended to 1/1/2005, comma, the petitioner did not carry out the instruction. Full stop. When the petitioner was again advised to collect the railway tickets dated 9/12/2004 to enable him to undertake the journey on 28/12/2004, comma, the petitioner refused to accept the letter. Full stop. It was the letter dated 5/1/2005 mentioned that it was under those circumstances, comma, the petitioner was released from the close of working hours on 27/12/2004 in order to enable him to undertake the journey on 28/12/2004. Full stop. But the petitioner neither collected the ticket nor he had reported for duty on Kunur. Full stop. The letter had further mentioned that in spite of being released on 27/12/2004, comma, the petitioner forcibly entered into the factory and marked his attendance and tried to do some works forcefully on 28/12/2004, 29/12/2004, 30/12/2004, 31/12/2004, comma, 1/1/2005, 2/1/2005, 3/1/2005, and 4/1/2005. Also, terming such actions on the part of the petitioner as unauthorized and illegal, comma, the letter had mentioned that illegal. Full stop. Para. Having regard to such materials available on record, comma, the observation, the finding recorded by the learned industrial tribunal that there was persistent refusal on the part of the workmen to join duty, notwithstanding the fact that management had done everything possible to persuade him and gave the opportunity to come back to the work, cannot be said to be a perverse finding. Full stop. Para. Certiorari jurisdiction. Para. Certiorari jurisdiction. Para. At this stage, no, full stop. When on a query made to the learned counsel for the petition as to whether the petitioner had joined at his new place of posting to carry out the transfer order, to carry out the order of transfer dated 27/4/2004, comma, as observed in the order dated 4/3/2023, comma, it has been submitted that the petitioner did not join at his new place of posting, that is at Kunur, Tamil Nadu subsequent to 4/3/2013. Post. In view of the discussion made above, this court does not find any good and sufficient reason to depart from the view that has been taken, to depart from the findings that has been recorded by the learned industrial tribunal in respect of the issues referred to it by the reference dated 11/11/2008. As a result, the writ petition is found to be bereft of any merits and is liable to be dismissed. It is accordingly dismissed. There shall, however, be no order as to cost. Because this custom is not your pleaded case.
Yes, it's not on paper.
I have stopped Somaria also from making submission, which is not a pleaded case.
That's good.
And I have to be,
That's apply there,
treat both the sides equally.
apply there.
Maybe. Lord, as far as item number 5 is concerned, my lord, I have been told that there is a talk of compromise is going on. So let
Yes,
this- Let this matter be posted after 10 days. my lord.
Lordship, I am appearing for the respondency at number 5. The only difficulty that the EPDCL is facing is since this matter is pending, some observation from your side, from your lordship that we are at liberty to at least consider this proposal. Your lord.
For any proposal pending.
Proposal is
Some talk of compromise is going on.
Okay.
Meetings were held, my lord. So your lords may kindly grant.
Heard Mr. S.K. Kejriwal, learned counsel for the petition, and Mr. K.P. Pathak, learned standing counsel APDCL for the respondents. Full stop. It is submitted by the learned counsel for the parties that the any scheme is there.
scheme is not there.
The parties are at a discussion to settle the matter outside the court in an amicable manner. Full stop. The learned counsel for the parties have therefore submitted that the pendency of the writ petition shall not
May not be a bar for APDCL to decide. to
may
take
not be a
decision.
bar for the parties to arrive at an amicable settlement outside the court. So having regard to submissions made, it is observed that pendency of the writ petition shall not be a bar for the parties to arrive at any amicable settlement outside the court.
Matter may be
Right.
posted.
As sought for by the learned counsel for the parties, release the case After 10 days?
10 days.
Some,
20
some, because we'll have to take the decision at the board of director level. my lord.
After
3 weeks.
after the ensuing puja vacation?
Yes.
After the ensuing puja vacation. Full stop. Anything is operating
Yes, well, interim order is there, my lord.
Interim-
That is,
or until?
no, my lord, and that is money for, we have paid the entire amount as demanded by APDCL. my lord.
Okay. Next.
Of like,
Mr. Pathak, will record the facts if possible?
Yes.
If it is not possible to record the findings, at least we can record the facts. I have forgotten in the meantime.
Lordship,
Let me recapitulate.
lordship.
You were there, Mr. Bora? We'll record the facts at least. Petitioner is what kind of any industry?
Petitioner is a tea garden,
Okay.
tea company,
Key company,
tea company.
key company.
The present petition. We may not conclude also, but we'll read the present petition. Under Article 226 of the Constitution of India has been preferred to assail an order dated 10/12/2012 passed by the appellate authority what is it called?
Appellate authority under section 127 of the Electricity Act.
Under section 127 of the Electricity Act 2003. In appeal number 12/2012, page 33 of the packet of it, Messrs. Parvati Tea Company versus Area Manager APDCL Dibrugarh and others. Full stop. By the order dated 10/12 by the appellate order dated 10/12/2012, the appellate authority rejected the appeal preferred by the petitioner against the final assessment bill amount of rupees 12,66,844. Right?
Yes, sir.
Full stop.
Like,
By rejecting the appeal, it was held that it had upheld the final order passed by the assessing officer and the petitioner was directed to pay the balance amount or balance 50% of the assessment bill dated 22/6/2012 with searchers as per existing rules within 15 days from the date of the appellate order, as the petitioner had deposited 50% of the assessment bill dated 22/6/2012 at the time of preferring the statutory appeal. The facts relevant for the purpose of the instant writ petition can be exposited as follows. The petitioner, a registered partnership firm, is a consumer under the respondent Assam Public Distribution Company Limited with APDCL. Having a and bearing consumer number TEE-2/48 with a connected load of 215 kilowatt and transformer capacity of 500 kVA, right? Full stop. And it is routine inspection.
There was a routine inspection on 22/3/2012.
Hmm.
2 inspections.
Basically, it is 16.6. They are agreed.
They agreed with 16.
Full stop. From the no, the an inspection of the electricity connection or what?
Inspection of the premises.
The election or the an
Inspection of
inspection,
meter.
an inspection of the meter installed in the premises of the petitioner farm was carried out on 22/6. Mr. Gautam, you be there at 22/3/2012 by the officials of the respondent APDCL. And there was another inspection, another such inspection on 16/6/2012. Full stop. When the inspection was carried out on 22/3/2012 in the premises of the petitioner for checking the metering condition, CMRI analysis was carried out and no irregularity was detected in respect of the electricity meter installed in the premises of the petitioner. Full stop. The seals, etc. were found to be seals, cabinet box, optical port, etc. were found to be intact. Full stop. But when the next inspection was carried out on 16/6/2012, and CMRI, what is CMRI?
Common meter reading instrument.
When analysis, when the metering installation, electricity meter installation was checked by common meter reading
Instrument.
CMRI, huh? A2 CMRI to agote CMRI লিখো তাতে লিখি দিব এতিয়া huh? It was detected that page 19 the installation of cable meant for 15 within bracket R capital, P small, H small, bracket close, comma 38 and 35 within bracket, B or P, I don't know. B, P, H. Underline quotation. Were found stripped off over a length of 5 mm to 6 mm. How many? This much. Okay. 1 centimeter. Okay. Before entering the meter terminals inside the cabinet box. Full stop. The inspection report prepared on 16/6/2012 recorded that the stripped off portions were found to be covered with pieces of PVC tapes. Full stop. It was the inspection report further recorded that the tapes were, the pieces of tapes were removed and sealed in presence of the consumer, and resealing was done without rectification of the metering system. Full stop. Para. Stop. Para. The inspection carried out on 16/6/2006
2012.
to 12 with the resultant inspection report led to the issuance of a provisional assessment bill dated 20/06/2012 for an amount of rupees 53 lakh 76,720. Post of the said provisional assessment bill prepared the prepared bill dated 20/06/2012 was served upon the petitioner with the further information that the said assessment bill had been prepared for malpractice under clause 5A
5.8.3.
5.8.3 and 5.A.4 of the this one,
Yes, sir. Yes, Your Lord.
Assam Electricity Regulation Commission within bracket Electricity Supply Code and related meters bracket close. Regulations 2004 within bracket, okay, Regulation 4 as amended. And notified by the Assam Electricity Regulatory Commission. Full stop. On receipt of the provisional assessment bill dated 26/2012, comma, the petitioner submitted its reply its objection against the provisional assessment bill containing inter alia, comma, to the effect that there was no tampering of the metering system full stop. It was contended that the inspection, whatever the inspection team had found as per the inspection report dated 16/6/2012, comma, was inside the metering cabinet without any broken seal, and it was impossible to tamper with the metering system without breaking of seal, comma, which were found intact. Full stop. Reference was made to the previous inspection carried out on 22/3/2012, when no irregularity was found with the metering system, comma, to contend that it was impermissible on the part of the, what do you say, licensee or what?
License.
Licensee to raise a bill for a period of 12 months by the provisional assessment bill dated so and so, when the CMRI analysis carried out on the metering system installed in the inside the premises of the petitioner on 22/3/2012, comma, did not detect any irregularity. Full stop. Assailing the provisional assessment bill as unjustified and arbitrary, comma, the petitioner requested the licensee to provide the CMRI reports, comma, dated 22/03/2012 and dated 16/6/2012. Full stop. Para. This 26 is before assessment authority, page 26.
Page 26 is before the area manager. It's
So assessment authority.
before assessing.
Okay. A hearing His signature is available.
His signature, your lordship, at the bottom of the page, your lordship, of page 26.
No. No, consumer.
Consumer signature,
No, who was there on first date?
yes, member present from the consumer, Bimal Goenka, partner.
A hearing took place before the provisional assessment bill con 19 niki 1960 not 26 our provisional bill 1906, right? Bill number 0783 dated 1906. A hearing in relation to the provisional assessment bill number so and so dated so and so took place before the assessment authority on 22/06/2012 in presence of the representatives from both the sides. Full stop. The contentions from the minutes of the hearing on the hearing which took place before the assessment authority issued under the hand of the assessment authority, go to indicate that the objection filed by the objections raised in the objection, written objection from the petitioner was taken note of and other relevant documents were perused. Full stop. The assessment authority had thereafter made the following observations, page 26. 1, 2, 3, tinda. Following up, minutes dated 22/6/2012. Full stop. By a subsequent letter dated 12/6/2012 on the subject of assessment and in reference to provisional bill number so and so and subsequent hearing held on 22/6/2012, the decision of the committee was conveyed to the petitioner. Full stop. It was informed to the petitioner that the committee had decided to assess the quantum of energy loss from 22/03/2012, that is, from the date of last inspection carried out by T and Roman and C division in the premises of the petitioner. Post up. By the letter dated 25/6/2012, the petitioner was served with a final bill amount of rupees 12,66,844, and the petitioner was directed to deposit the said amount within 15 days from the date of issue of the said final bill. Post up. The petitioner was also informed that if the petitioner intended to prefer any appeal, the same can be preferred before the appellate authority after observance of all the formalities. Full stop. Para. Agreed by the final assessment bill for an amount of rupees 12,66,844. The petitioner agreed with the final order of assessment made under Section 126 of the Electricity Act 2003, by assessment order number 144 within bracket small a dated 25/6/2012, the petitioner preferred a statutory appeal under Section 127 of the Electricity Act 2003 by depositing %50 of the assess amount in compliance of the provisions contained in subsection 2 of Section 127 of the Electricity Act 2003. The appeal was registered on receipt of the appeal, the appellate authority registered the appeal as appeal number 12/2012. As the appeal was found to be within time, the appellate authority proceeded to hear the appeal full stop. During the course of hearing, which took place on 25/7/2012 and 21/11/2012, the appellant, the respondents, and the inspecting officers were present. Full stop. The appellant was represented by its authorized representative, that is, a partner of the partnership firm before the appellate authority. Full stop. After hearing both the sides, the appellate authority reached the conclusion that the final assessment bill of rupees 12,66,844 raised by the assessment authority needed no review. Full stop. By holding so, by concluding so, the appeal was dismissed and the final order of assessment passed by the assessing officer was upheld. Full stop. The appellant was directed to pay the balance 50% of the final assessment bill dated 22/6/2012 with charges as per existing rules within 15 days from the date of passing of the appellate order. Full stop. Aggrieved by and dissatisfied with the appellate order dated So and so. It took alone. Huh? 12, 10/12/2004. The petitioner has preferred the instant writ petition. Post up. I have heard Mr. K. Chaudhary, learned counsel through the virtual mode, and Mr. P. K. Bora, learned counsel for the petitioner, and Mr. K. P. Pathak, learned standing counsel, APDCL. Post up. What were the submission? 1 minute, his decisions. 2 decisions were cited, perhaps. Rajashree T. Mukesh Mehta. You submitted 2 decisions, right, Mr. Pathak? 3.
I submit
2 or 3?
3.
3. One is Suryadev Rai.
Suryadev Rai,
The other is Savarn Singh.
and one is Puneet Bagaria.
এখন খুলি গৈছে মাৰি দিয়কচোন এইটো পিনটো মাৰি দিয়ক পুনীত বাগাৰীয়া পুনীত বাগাৰীয়া It is contended on behalf of the petitioner that the meter was installed in the premises of the tea factory of the petitioner full stop. It was submitted that when an inspection was carried out, just 3 months prior to the inspection on 16/6/2012, that is, on 22/3/2012, no abnormality was recorded in the inspection report. Full stop. So the act of raising a professional does in such situation, the act of raising a professional bill for a professional assessment bill for a period of 12 months was clearly an arbitrary act. Full stop. Arbitrary act, and it goes to signify that the assessing authority goes to signify that there was no application of mind on the part of the assessing authority when he was exercising the jurisdiction under Section 126 of the Electricity Act 2003. Full stop. it was only after the petitioner had raised a valid objection through its written objection dated 20/06/2012, the final assessment bill was prepared for a period of 3 months. Full stop. It was contended that as the seals of the electric meter were found to be completely intact during a inspection on 16/6/2012, it is clear that no tampering with the electricity meter took place. It was an allegation has been leveled to the effect that while contending that, it is not possible on the part of the consumer to affect such tampering, an allegation is leveled that the act of tampering, if any, would have been possible on the part of the APDCL personnel at the time of inspection. Full stop. The petitioner has contended that the appellate authority had dealt with the manner, had dealt with the appeal in a very casual manner. And without any proper appreciation, came to the conclusion that the allegation made against the petitioner was true. And there could be no way the APDCL personnel could be held responsible for such mischief. The finding recorded by the appellate authority to the effect that stripping of the cable in the metering system was abnormal. Was challenged on the premise that such kind of alleged tampering could not have been possible on the part of the petitioner as the consumer, and could have been possible on the part of the personnel from the inspection team as they were trained and experienced with with such kind of metering system installed inside inside the premises of the petition. Full stop. It is the Learned Counsel for the petitioner has contended that the findings recorded by the appellate authority in the impugn order dated so and so are verse one, as there was no discussion, no proper discussion, and appreciation of the version projected from the end of the petition. Mr. Chaudhary, the decisions to in support of such submissions, a decision of the Honorable Delhi High Court in Mukesh Mehra versus BSES Jamuna Power Limited, reported in 2010 SSC Online DEL 723. And of this court in so and so versus so and so, reported in 2019 2 ZLR 116 have been relied on. Full stop. Mr. Pathak, Learned Standing Counsel, APDCL, has submitted that there is no ground to interfere with the findings recorded either by the assessment authority or by the appellate authority, with which the assessment order stood merged. Full stop. It is contended by him that as the jurisdiction of the appellate authority is to jurisdiction of appellate authority to appreciate the to determine questions of fact is co-extensive with the primary authority, the findings of fact arrived by two fact-finding authorities are not to be disturbed unless there is perversity in the findings of facts. Full stop. Referring to the contents of the appellate order, Mr. Pathak has contended that the appellate authority had considered the versions urged by both the sides and had considered the same. Full stop. In addition, the appellate authority had also looked at the physical. There was physical something.
Photographs were there.
Photographs. Full stop. He has submitted that. The appellate authority had recorded a finding after proper assessment, appreciation, that subsequent low consumption after 22/03/2012 till resealing corroborated the fact that the metering system was tampered. Full stop. He has contended that unlike, contrary to the projection made on behalf of the made by the petitioner, made on the made by the petitioner to the effect that the custodian of the metering system is the licensee, it is the consumer who is responsible for the safe custody of the meter, cutouts, MCB, CB, etc. If such installations are inside the consumer's premises, in terms of clause 4.2.1.2.5 of the regulations 2004. It is short for you. We try to continue on Thursday
Thursday, can my colleague be here? Actually,
or
I-
yes. Mr. Pathak has placed reliance in to buttress his submissions, Mr. Pathak has placed reliance in 1, 2, 3. 1, 2. Itu go by. Okay. 1, 2, and 2. Order Bagaria. Itu Bagaria. Sujade. Koran, tinta. I have given due consideration to the submissions made by the learned counsel for the parties and have also gone through the materials based on record by the parties to their pleadings. I have also gone through the appellate order dated so and so, passed by the appellate authority in appeal number so and so. That might be good. Maybe Thursday, I may be running short of time.
Then, Thursday,
Tuesday. I may have to leave early.
Thursday, when I was going to be in Difu,
Maybe on Mr. Bora,
Tuesday.
Tuesday? Partner, what do? Punura. This is top of the list, no? This is top of the list, no? I heard Mr. Swenson and the hearing remained inconclusive. Please the case on Tuesday as partner. In the top of the list category. Again, in the top of the list category. It will come automatically after. Where is Mr. Morpujarian?
And
Gautam. Itu Bagaria to Yare. Yare. One and Gautam and R. Morpujari. Are they available outside the courtroom?
I think.
Huh? After the level
Yes.
court, it is very difficult.
Come back to electricity.
Subjects are different.
Yes. Completely different.
Completely different. Yes, Mr. Gautam. Where is Mr. Borpujari? I have to record his consent also in his presence. Now it is very difficult. Though day before yesterday he consented. Now everything is live streamed. You will say my consent has been wrongly recorded. Try to call him. Okay, you may go. It will do arbitration. Arbitration conciliation action. Yes, Mr. Parak, do you have any idea, or Mr. Bora, in case of arbitration petition under section 11(6), if the parties give consent to an arbitrator who is not in the panel of list, it can be.
The panel is only directory, Your Lordship. It is not. If they consent, then there is
consent. The present application is under 11 within bracket 5, read with 11 within bracket 6. One is labor, second is electricity, third is electricity. The present application is under section 11 within bracket 5, grade with section 11 within bracket 6 of the Arbitration and Conciliation Act 1996, praying for an appointment of sole arbitrator by this court. First, heard Mr. N. R. Chaudhary, learned counsel. Heard Mr. Learned counsel in the virtual mode, and Mr. N. Gautam, learned counsel for the petition. Huh? Is he available? And Mr. R. Borpuzari, learned counsel for the respondent. The petitioner is a company is incorporated under the provisions of the Companies Act, 2013. And the respondent is a partnership firm. Is a firm registered is a firm is a partnership firm. Registered under the provisions of the Partnership Act 1932. Full stop. আগতো লিখিব having its registered office at Guwahati, আৰু ইটো লিখিব having its registered office at Guwahati. Full stop. It is the case of the petitioner that in and around the year 2009, that's 2009/2010, the petitioner had started undertaking a project named Meghamallar City Center Residency at Torunnagar for the purpose of developing constructing multi-storied residential building apartments. Full stop. Due to reasons as certain problems arose, subsequently, the project was handed over to the respondent by entering into a memorandum of understanding dated 9/11/2019. It was decided that 1. Roman 1. All development rights belonging to the petitioner, along with the power of attorneys, would stand transferred and assigned to the respondent. And Roman 2, the respondent would take the entire project from the petitioner, including all rights and liabilities of the petitioner, who are the landowners and the project. Full stop. Subsequent to the execution of the MOU, the petitioner registered deeds of rectifications and registered power of attorneys who had executed with the concerned stakeholders. Full stop. Finally, on 6/6/2020, a deed of agreement was entered into inter alia defining the consideration to be given to the petitioner by the respondent for taking over the project by the respondent from the petition. Full stop. In the subsequent period of time, dispute arose as regards inter alia as regards the area of allocation of the petitioner. Full stop. Any notice?
Arbitration notice, Lordship.
The clause 49,
Lordship will find it at page number 57. in the-
clause 49 of the deed of agreement dated 6/6/2020 contained an arbitration clause to the effect that in the event of any dispute or controversy between the parties, the parties to the agreement would settle their dispute arising out of or relating to the agreement inter alia by a sole arbitrator. Full stop. Para. Under the provisions of the Arbitration and Conciliation Act 1996. Full stop. Para. The by a notice dated 10/2/2023.
12 from March 20. 12. 12/3/20.
Huh?
12/3/2020. 12 from March 2020.
12/3.
Yes, sir. Lordship, page number 57. Lordship.
But
Next.
paragraph 23 wrongly mentioned that by a notice dated 12/3/2023, the petitioner invoked the clause of arbitration Full stop. Vera. The learned counsel for the parties.
He's on lake 17, my lord.
Huh?
He's on lake, my lord.
Okay. Has submitted that. So facts are recorded.
My lord, I beg
The learned counsel for the parties have conjointly submitted that they have agreed for the appointment of Honorable Mr. Justice
CP Koto.
BP Kotoki, former judge, grant of this court to act as the sole arbitrator for resolution of the disputes between the parties. Full stop. Para. In view of the consensus so arrived at as regards the sole arbitrator, the this court in exercise of the power conferred by section 11 5 and section 11(6) of the Arbitration and Conciliation Act, 1996. Appoints Honorable Justice Mr. Justice BP Kotoki, former judge of this court as the sole arbitrator to decide all the disputes arising out of the agreements executed between the parties, subject to the mandatory declaration required to be made under the provisions of the Arbitration and Reconciliation Act. I'm not referring to the provisions. And as regards the period of completion of arbitration proceeding, we need a period as per section 29A of the Arbitration and Conciliation. Full stop. The parties will accordingly appear before the sole arbitrator within a period of 1 month from today.
Yes, my lord, that can also be done conversely, my lord, with
The parties subject to his willingness.
yes, my lord.
Subject to his willingness.
My lord, I have given a decision of this honorable court, my lord, that will help, my lord.
And subject to his willingness,
Subject to his willingness and my lord,
in writing.
and
as per the notices to be issued by the tribunal so constituted. We will appear on the date that will be mentioned in the notice, my lord.
Hmm.
Because the
Where is that? It is what
1 month, my lord, because if no date is fixed, my lord, we do not know. So that 1 month is there. Conversely, lordship may skip that and my lord may direct that parties will appear in accordance with the notices that may be issued, my lord, by the arbitral tribunal to be so constituted.
subject to between the parties, observer subject to the mandatory declaration required to be made under Section 12 of the Act with respect to independence and impartiality and the ability to devote sufficient time to complete the arbitration within the period as per Section 29A of the Act. Full stop. A copy of the order be dispatched to address
My lord, that the registry knows, my lord. So maybe rotate to the
dispatched to okay
to the registry
To-
of the honorable court.
be dispatched to Honor Mr. Justice BP Kotoki at his address. Full stop. The parties will appear before the learned arbitrator within a period of 1 month from today, and the learned arbitrator will proceed in accordance with law. After that, this is the order.
No, this is the order, my lord. Lordship, the other.
No, no, not fixed that. It's subject to convenience. He may not be there, he may be there, we do not know.
No, so therefore, my lord.
Within a period of 1 month from today.
In any case, they'll be duly be informed whenever the date of appearance is.
No,
they will be
because
informed.
we just
Both the
cannot go
parties
and
will be
appear, my lord, because lordship has appointed, my lord, honorable.
On consensus.
Yes, my lord, honorable Farmers as the arbitrator. Now, on being appointed, my lord, he will act as an arbitrator, meaning thereby, my lord, an arbitral tribunal comes into constitution. And my lord, that arbitral tribunal, under his seal and signature, my lord, will issue notice to the parties.
Which order you have shown to
Well,
me?
it is not there, my lord.
Not there.
But normally, but yes, there are orders, my lord, that I couldn't get hold of immediately, my lord.
Okay, I will go by this.
My lord,
Next time I'll
my lord.
find out. The
Right.
parties will appear before the learned arbitrator within a period of 1 month from today, and the learned arbitrator will proceed in accordance with law. Full stop. With the above observations and directions, the present petition stands disposed of.
My lord. I'm deeply obliged.
Dispatched to so and so for his information and necessary action.
Yes, my lord. Yes, because
For his information and necessary action.
he may not, my lord, to extend his willingness, my lord, to it. That
Because
is
I
the-
cannot also fix a date for appearance, right?
Yes, that's right.
He might be busy in some other commission, some other arbitration.
Therefore, it is within 1 month, any date, my lord, that may be, my lord, fixed by the him.
Item
Okay.
number 8.
1 month, let it remain both. For his necessary action also will remain, and 1 month also.
Yes, yes, no difficulty, my lord. I'm deeply obliged.
Anything?
Eight.
Yes, sir.
Hearing.
Lordship, in item 8, Lordship, the respondent, Power Grid Lordship, the council left under the. impression
Okay.
for the matter.
Power grid.
Power
Let over কৰি দিব। What is labor method or what method? See manager চাওঁ। কিমান পুৰণি? Labor নহয় চাগে। Huh? Yeah, process board, this taking. Okay. 10 the compensation. Compensation is compensation আমার নেই। Huh? Councils are not present. It is not a matter pertaining to bench 4. It is bench 5 compensation under section 10D. থাকো করো, ওটা পয়েন্ট পার্টি নাই।